Yes, sir. Am I? Yes.
Are you Mr. Frost? Yes, sir. Okay. You let Richard know we're going to be getting Mr. Frost case.
Okay.
I don't see Department of Corrections connected yet.
Okay. I'm sorry. I'm sorry. I didn't realize that he was coming back from DOC. I apologize.
No. Mr. Gilo, we're waiting for Department of Corrections to connect with Mr. Kraft. So if you can just stay on the line.
That'll be fine, Judge.
Okay, thanks. Oh.
He's on a Zoom call with Judge Cooper.
Okay, that's fine. We've got Andrew connecting now. Sorry, I know I'm ahead of schedule here, Mr. Trush. I was just trying to. Are you ready to proceed?
I am. And in case the court is not aware, Mr. Plickett is in the jail. He's the next one up after Mr. Frost.
Okay.
They went down to get him.
Okay, Mr. Frost, if you come up to the podium, please. And Mr. Kraft there at Antrim County, we're going to start your case in just a minute. So we've got another case going, but we're going to call your. You can just stay on the line there. We'll go on the record in People versus Cody Frost, case number 246726. The record reflecting Mr. Frost is present here in the courtroom today. This is the date and time set for sentencing in this case. And Mr. Frost, have you had an opportunity to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, sir. I talked to him on the phone Friday.
Okay. And Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do people have any additions, deletions, or corrections?
People, no additions, deletions, or corrections as to the body of the report, no challenges as to the scoring.
Thank you. Anything on behalf of the people for allocation?
Just briefly, Judge, the 10 claim situation, similar in this case, to a degree more vehicle code. As I understand it, it's going to be county time, pretty much unless the court goes beyond the guidelines. And as to work camp, if employed, gets 2 days credit, but that's a circumstance we're not going to report on. I mean, I think some jail time is appropriate, obviously, for the LA and get on court, whether up to 2 years within the first selection.
Okay, thank you, Mr. Trush.
Thank you, Your Honor. I think these cases are always difficult cases to sentence. And I say that because the prosecutor is accurate in terms of what the prior record is, and that's not good for Mr. Frost. The other side of that coin, though, is what he's done since this event has happened. I think Mr. Frost will openly acknowledge to you that he struggled with substances He is actively engaged in treatment and doing very well with that treatment right now. I can identify personally, I've observed him sort of in the recovery community through some of the things that I do in that community. So I know he's engaged in that community. I know he's working, he's gainfully employed. So this is a difficult case for the court to sentence. I think we have to balance the punishment element of it with encouraging him to continue with the recovery and with the positive changes that he's made. I think he's going to tell you a little bit more about some of the recovery things and the positive things that he has going right now. But ultimately, I think that the right balance is struck with the recommendation, which is county jail, but allowing him to utilize the work camp program so he can continue the positive steps he's taken forward. And frankly, if he backslides and doesn't continue to do that, he's going to serve the jail. Thank you.
All right, thank you. Mr. Frost, anything you wanted to say today?
Yes, Your Honor. I am truly deeply sorry for standing before you today as the problem, not the solution. I am ashamed that I relapsed and let my life spiral out of control. And I terribly regret putting my family through the misery they endure because of my addiction. I apologize to my community for being a menace. I do recognize the importance of being a good, productive member of society, and I have taken action to prove how truly sorry I am. Since the incident, I have constant contact with my recovery coach from FAN. I have attended self-help groups consistently 3 to 5 times a week, including CHS, AA, NA, FAN, or Bible study, in addition to church on Sunday, volunteering when available. Being aware of and managing my mental health and medications is critical. I've maintained and excelled at my job as a carpenter, and I've been able to pay my bills and stay current on child support. And I've maintained a perfect record with my alcohol tether. Last but not least, the miracle, my recovery coach helped me get my son back into my life. For the first time in 10 years, I have court-ordered visitation of my son. In conclusion, I plan to prove how truly sorry I am. I will prove my value to society, and I take full responsibility for my recovery, God willing, one day at a time. Thank you for this chance, Cody Frost.
All right, I did read through the report, so I'm familiar with the circumstances here. Of course, I'm familiar with your past history from previous cases, as well as the information contained within this report. And yeah, I mean, I agree with what the lawyers have said here. Past history is certainly awful, the number of convictions that you have, and it certainly provides the court with some reason to find that, you know, this is just a continuing pattern that's going to continue forward. It sounds like you are making some strides now to work on your problem, which is underlying all of your criminal convictions. And the real question is whether or not that's going to last. You had some periods where you've done well in the past, and then the relapses. I understand that relapses are part of addiction. It happens, but at some point you're gonna provide the court really with no other options other than prison, and you're close to that point now. I mean, the guidelines here are 10 to 23 months. So, you know, I do think it's appropriate, given the work that you're putting in now, to give you an opportunity to continue with that. But I think, you know, and I probably don't even have to say it, is there's not going to be much room for you to mess up here, because you've already had so many opportunities. You've been on probation many times, been many jail sentences. There's really no more room for you to mess up. If you're going to do it, now's the time to do it. Given all of the circumstances here and the information in the report, including the recommendations in that report, I am going to follow those recommendations. The court is going to sentence you to Gaseo County Jail for a period of 12 months. You have credit for 2 days served. Again, for the yes, I don't have an objection to your participation in the work camp program during that time. But I'm going to tell you, if there's any indication from the work camp program that you're not following their requirements, no issues, just putting you in jail for that time. But as it stands now, given the work work that you're putting in here, and it's appropriate to give you an opportunity to continue that. And I hope that you do. I really
Yes,
do.
sir. Thank you so much.
We're also going to impose a crime victims assessment of $130, court costs of $325, attorney fees of $350, and $68 state costs. You do have the ability to seek an appeal of the sentence. Cross technologies.
I wasn't able to speak with him this morning. I am in the process. I had a doctor's appointment yesterday and I have another one scheduled the 18th to get my medication changed. And so I'm hoping you'll leave me on tether until I can make that appointment and then transfer to, so maybe even my time won't start until I can make this doctor's appointment on the 18th. It's for the Sublocade and my Wellbutrin comes back for Jessica Van Wolfen as positive for meth. And so she has to wait, send that off. With with Jessica, she lets me be free until she gets that result back. But if I go to jail, they're gonna make me sit until I get that result back. And so I have a doctor's appointment on the 18th to get the Wellbutrin changed and to get a Sublocade shot. So I don't have to deal with Suboxone. And I tried getting, and I knew this ahead of time and tried getting it taken care of. I had a virtual visit yesterday. So I thinking I could get it taken care of yesterday. And I have to see him in person in order to do the shot. So we scheduled an in-person visit for the 18th.
You know, I'm in the business of sentencing and giving you the opportunity to participate in the work camp program. I'm not involved in how shots work, what the jail rules are. You know, I'm not going to get involved in that. If I get involved in that, Mr. Frost, then I'm doing something outside of the scope of what my role is here as the judge. So I'm willing to help facilitate, but I'm not going to jump through a bunch of hoops to try and figure out how you can get released to work camp and work its way to that. It's not my role.
Would the court order the tether continue for 2 weeks?
I don't even know. Like, I have no idea what the parameters of the tether are. I don't know whether the jail allows that under their rules or not. Again, this is outside of the scope of what I do. My job is to sentence the defendant. And you guys can figure that out. I'm not going to try and parse out how all this is going to go. So,
I mean, I'll stick through it, but
none of this has been a surprise. I mean,
I
so
get it. Yeah. Could I maybe even turn myself in tomorrow morning to get these affairs in order?
no, I mean, today's the day.
Okay, that's what I get it.
Either you're set up or not. Again, it's not.
Yeah, can I grab my bag? Okay. Are you heading over there? It's in the next door. Just tell me when.
All right, Mr. Kraft, we're gonna need you, I don't know, you might need help from one of the corrections officers to unmute on your end, please. Okay, great. Sir, is your name Brandon Kraft?
It is.
Right, we're on the record in People versus Brandon Kraft, case number 246727. The record should reflect that Mr. Kraft is present today by video from Antrim County Jail. This is the date and time set for sentencing this matter. Mr. Gilo, did you have a chance to go through the pre-sentence report with Mr. Kraft?
Yes, Your Honor. We went through.
Okay. And Mr. Kraft, did you have an adequate opportunity to go through that report with Mr. Gilo and talk to him about that?
Yes, Your Honor.
Great. Mr. Gilo, are there any additions, deletions, or corrections that need to be made to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No challenge to the guidelines.
Thank you. Mr. Rolla, do the people have any additions, deletions, or corrections?
For the record, I would note that people who are discontinued corrections as I report more challenges as the scoring.
Anything on behalf of the people for elocution today?
Very briefly, Judge, the first felony situation, it's possession, not, I don't know if you discussed issues that our county faces, nothing, and the abuse thereof. It's a recommendation of jail with 2 days credit. That's appropriate. It's my understanding as well that as the defendant has been able to post his bond in Antrim County Construction Judge. Yes. Thank you.
Thank you, Mr. Trush, or I'm sorry, Mr. Gilo, anything on behalf of Mr. Kraft today?
Well, Your Honor, my client's taken responsibility for what happened here in Otsego County. As well as you know that he's taken responsibility in Antrim County and has pending other pending cases. Obviously, my client has had a drug issue with respect to committing these crimes, and he's readily admitted that he did have that drug problem and that he did commit the crime. So I'd ask the court to take that into consideration with respect to any sentencing in this matter. Thank you.
Thank you, Mr. Kraft. Anything that you wanted to say today?
Just that since I got in trouble over there, I've been to treatment successfully, and I'm continuing treatment in jail. And I'm also going to be a father in November, so I'm trying to get better for that. But that's all. Thank you.
All right, thank you. I did review the report, so I'm familiar with the circumstances that bring you before the court today. I'm also familiar with your past history and circumstances based on the information that's contained within that report. I've reviewed all of that. Looking at the circumstances as a whole, Mr. Kraft, you don't have a serious felony record at this point. You've had a couple jail sentences, but your record isn't too serious at this point. Of course, that's not counting what you got going on there in Antrim County, and I'm not sure how those charges will be resolved. But based on the circumstances in this case and your history at the time that these charges occurred, the court finds that a sentence within the guidelines, in the middle of the guidelines, is an appropriate sentence to address both your conduct and your past history. The court is going to sentence you to 6 months in the Otsego County Jail. You do have credit for 2 days served. That time would run concurrent with any time that you're serving or will serve in Antrim County. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, a DNA testing fee of $60, and a $68 state cost. You have the ability to seek an appeal of this sentence. If you haven't already received it, the court is going to provide you with some paperwork that explains to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with any appeal. Mr. Rolla, is there anything further that we need to address on the record today? Mr. Gilo, is there anything further that we need to address today?
No, Your Honor.
All right, you are remanded to the custody of the county at this time. Kraft, and good luck to you going forward. The court is going to disconnect.
Thank you.
versus Raymond Plickta, case number 246731 and 6732.
The record, Your Honor, my call back to people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Plickton.
The record should reflect that Mr. Plickta is present here in the courtroom today. This is the date and time set for a sentencing hearing in this case. Mr. Plickta, have you had an opportunity to go through the pre-sentence report and talk to Mr. Trush about that? Okay. Mr. Trush, have you had a chance to go through that with Mr. Plickta?
Yes, we have.
Are there any additions, deletions, or corrections to that report?
There is, Your Honor. So starting with CFJ 145, page 1, under the section titled Personal History, specifically Substance Abuse History.
Okay.
There's 2 boxes in there that include methamphetamine and THC. The dates of starting on this, I think, have to be errors. One of them predates his birth and the other would be at age 2. He reports that the substance abuse started around age 18, so around 2010 or so.
Scroll, any objections to that change?
No, Your Honor, thank you.
Make that change. Next one, Mr. Trush.
I wanted to indicate to the court, and I think this is just a factor of how the charge reads, but it indicates domestic violence against a pregnant individual. I just want to make a clear record. The victim in this was not pregnant when this happened. I don't know if it's a correction the court wants to make on the PSI, but I do want to make sure it's clear that's not the circumstance.
And actually, Judge, the statute says third offense, whether it's domestic violence or pregnant. So actually, it's technically correct because it's both the same statute. But if you wanted to add third offense, domestic violence or pregnant individual, that's fine because that's what the statute is.
And I mean, on my copy, it does say and or. So, and I recognize completely that based on the information in the report that the individual was not pregnant. So I would acknowledge that for the record. But the statute is titled the way it's titled.
But I understand. Those are the only corrections we had.
Okay. Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do the people have any corrections?
No, Your Honor, thank you.
People have any challenges to the scoring of the guidelines?
No, Your Honor.
I know from the report that the victim was asked to give a statement.
She's present, Judge.
Oh,
I'm
she
going to
is.
give her the opportunity if she wants to take it.
Mr. Trush, if you and your ma'am, are you Ms. Huffman?
Yes, sir, I am.
Okay. What is it that you would like me to know about this case?
I would just like to say when it comes to Raymond Plickta, I would say he doesn't belong in a jail cell. He doesn't belong in the prison. I believe that he needs help. He needs help with his mental. He needs help understanding it. He's been lost throughout the system. Even though, yes, this is a horrible crime, it is a horrible thing that happened. One thing I've learned, mental illness never goes away. But I watched him in the last year work a phenomenal job, do a really good job, also help me raise a child. I just want to say I actually believe he needs help. He needs help understanding his mental, understanding how to live with it, how to deal with it, how to cope with it. Also help to deal with childhood traumas, things that he's been through. I know life hasn't been fair to all of us, but life has really been unfair to him. And I just want to stand in front of you today saying that I believe he needs help. He needs rehabilitation. And I think throughout jail and prison, I don't think that's helped him at all. That's all I have to say, Ron.
Thank you. I appreciate your statement today. Mr. Rolla, anything that you want to say before allocation today?
Judge, this is a situation we're talking about a 6th felony, defendant's only 31 years old. And I understand the circumstances of the victim, taking that into consideration. There's a recommendation in this case of jail time. as opposed to prison time. And I think that that's appropriate, and we have no objection with following that with the 42 days for it.
Thank you, Your Honor. I think it's somewhat a rarity when everybody is identifying the exact same issues in the case. And I say that because going through the PSI, I think it's very clear that Mr. DeLeo identified Mr. Plick that has some mental health issues. He has some issues that he needs to work on. And I think he's been doing a good job of trying to address those issues since this event has happened, at least insofar as it's in his control. The victim spoke to you and again, identified the same things, right? Identified that there's mental health issues and there's work that needs to be done with them. And again, I think there's periods when Mr. Plickta has done well with it and there's periods where he struggled with it more. And I'm gonna identify the same things for the court. You know, there's mental health issues. I have talked to Mr. Plickta about, you know, identifying when he's having those moments, those issues, and finding ways to de-escalate or leave a situation instead of staying and letting things compound and get out of control. I think that being on a proper medication regimen is probably important to that. He recognizes that he needs to address those issues, and he recognizes that, frankly, he's not going to be giving the court options if he, you know, continues to leave them unaddressed. If he continues to do what he's done, he's going to continue to find himself in the same places. The positives for Mr. Plickta, though, again, I think he's done everything that he can within his power right now to address the issues. He spent the time that he has had in the jail trying to better himself. He's taken advantage of the GED program there, and I think is one module away from completing his GED. I think he still has to complete the math. But again, he's taking that time to try to make improvement. I think that's reflected in what Mr. DeLeo has recommended in terms of recommendation here. I think it's appropriate and would ask court to follow.
All right, thank you. Mr. Plickta, anything that you wanted to say?
Yeah, I'd like to apologize to you, Your Honor, in the court for my wrongdoings and my actions. I'd also like to apologize to the victim for the way I treated her, as I'm thankful for going to jail to give me time to realize that I need to be more consistent in taking my meds and about going to my mental health counseling appointments. And I take full responsibility for what I did wrong and accept the consequences that I received. So.
All right, thank you. I did read through the report. I take all that information into consideration, including the description of what happened in this circumstance that brings you before the court in these two cases, as well as your past history and so forth. Obviously, I take into account what you had to say here, as well as the lawyers, and of course, what Ms. Huffman had to say. That's important to me. That's the victim in this case. And looking at the report and the information in there, I have no doubt that you do have some issues that need to be addressed. A lot of the way that people act when they're adults is driven by experiences that they've had through their life, and when those are bad experiences, it leads to bad behavior as an adult, unless it's addressed. And there's multiple ways you can do that: through therapy, through medication, and usually a combination of those things are what's going to help. And I believe you do need to seek that out. I don't think, given the circumstances here, that a prison sentence is warranted. I think a jail sentence at the lower end of the guidelines is going to give you an opportunity to seek that help quicker than you would be able to if you were sent to prison. But the fact that you do need to address those issues doesn't negate your wrongful conduct. It doesn't mean that there isn't a punishment or consequence for your actions. And, you know, regardless of whether the court ordered you to participate in some type of counseling and treatment, ultimately you've got to do that yourself because you want to stop being in the situation you're in. And I hope that at some point you're going to get to that point where you're tired of this and you want to get help so that you have the tools to result in a better outcome when you have issues. So all that being said, I think the recommendation for jail time is appropriate in this case. The court is going to sentence you to 10 months in the Otsego County Jail. As to count one in file number 6731. do have credit for 142 days served in that file. Court is going to order crime victims assessment of $130, court costs of $325, attorney fees of $350, $68 state costs. As to file number 6732, court is going to order that you serve 93 days in the Otsego County Jail, credit for 98 days served, and that file is basically time served. Crime victims assessment of $75 and a $50 state cost. Have the ability to seek an appeal of these sentences. Mr. Trush, you can provide with notice of these appellate rights.
Your Honor, I have the executed appellate rights for 246731. However, for 246732, because it's a misdemeanor, I think just the oral appellate rights are appropriate, that he has 21 days to appeal that if he wanted to.
Correct. Thank you. Thank you for that record. Would you like to go forward? You ready on Mr. Butt's case?
Yeah.
A little early, but People versus William Franklin Butts, case number 246743. The record should reflect Mr. Butts is present here in the courtroom today. I'd like to have counsel put your appearances on.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Butts.
Thank you. Mr. Trush, I believe this is Mr. Butts' first appearance before the court on this charge. Tell me where things are at from your standpoint.
I'm sorry, Your Honor.
Okay. Thanks.
So, Your Honor, this is a little bit of a procedurally complicated case, and I indicate that because we're here on our first status conference on this file. We intend to ask the court to docket the matter for a trial, but I do want to indicate, and the court may well be aware of this, there also exists a probation violation hearing in Crawford County. And I actually was asking Mr. Butts, I didn't remember if it's in front of you or in front of Judge Hunter, but I think we have that hearing coming up maybe at the beginning of October. Ultimately, we want to address the underlying matter before we address the PV, and I know that doesn't affect what happens today, but I just want a clear kind of background of what's going on at a global scale. So our intentions today are we are asking it to be set for a trial.
Okay. Mr. Rolla, how many days trial do you think this will take?
Looks like we have 1, 2, 3, 4, 5 witnesses. Probably be done in 1 day.
I would tend to agree with the exception of the witnesses listed by the prosecutor. I anticipate that defense would likely have maybe one witness in addition to those. So I think 1 day is an appropriate time.
Okay. Mr. Rolla, do the people need any particular period of time to be ready for a trial?
Obviously, when we have lab witnesses, we're going to need some time, some leeway in order to get it. But if you have this at least 60 days out, it shouldn't be a problem.
I mean, I don't have any objection to whatever time frame the court wants, but I don't think there's any lab witnesses necessary in this. The allegation is home invasion.
Oh, I'm sorry, Judge. My apologies. Yeah, I looked at one of the witnesses. I saw the name. I thought it was a lab. It turns out it's not. So it may be one where we can do within less than 1 day. Depending on I wouldn't schedule any less than 30 days.
I don't think that'll be possible. Okay, so the court will set it for 1 day jury trial at 60 to 90 days. We'll set this for one final status conference prior to the trial date. That'll be cut off. So Mr. Butts, to the extent there are any further discussions about a plea, that final status conference will be the last day of that. Okay. Okay. And then Mr. Rolla, are you anticipating any motions being necessary prior to trial?
I don't see any right now, Judge.
Mr. Truitt,
I do not anticipate any.
to the extent either side has any final status conference date, your motion cut off as well. Mr. Rolla, any other dates that we need to address?
On this case.
Mr. Truitt.
No, Your Honor.
Mr. Butts, do you have any questions about how we're going to proceed on this case? Thank you. Mr. Evans, we have your hearing set for 10 o'clock, so I'm just going to put you on hold until that time.
Okay, okay.
Mr. Truitt, you have Mr. Fick on here. Court will call People versus Zachary Fick, case number 246747. The record should reflect that Mr. Fick is present here in the courtroom today. We have counsel for your appearance on this file.
Thank you, Your Honor. Richard Truitt, appearing on behalf of Mr.
What is the status of this file today?
Your Honor, we are in receipt of an offer from the prosecutor on this that we intend to avail ourselves of. That would be an added count to controlled substance use. That's MCL 333740442A-A. That's a 1 year, $2,000 max. And that is going to be with a second or subsequent offense enhancement, double the penalty. In exchange for that, the principal count of possession of methamphetamine and the habitual offender notice would be dismissed.
And are we taking the plea to the factual basis of the possession?
I think that would be an appropriate way to do it.
And no objection to the court taking that position.
And is that the correct statement of the offer?
It is, and then with the enhancement, of course, it's going to be a 2 year.
Okay. So we are keeping that enhancement.
Well, just to be clear, so the second or subsequent offense controlled substance enhancement, the drug double is there.
Okay.
The habitual second is being dismissed.
All right, understood. Okay. Mr. Fick, have you had an opportunity to speak with Mr. Truitt about this plea agreement?
Yes, Your Honor.
And what the lawyers have said here today in court is that the agreement that you spoke to. Is that how you want to? Raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Mr. Fick, are you currently on any kind of probation or parole? You understand, as counsel's indicated, that the maximum possible penalty that you face for this charge, which is use of methamphetamine, will be up to 2 years and or a $4,000 fine. With that maximum possible penalty in mind, what is your plea to that charge today? Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty today?
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. If they said no, then you wouldn't be able to go any further with that appeal. If you understand that. Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what was said here in court?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are in fact guilty of this crime?
Yes.
This happened on June 25th of this year, is that correct?
Yes.
On that date, were you here in Otsego County?
Yes, sir.
And while you were here in Otsego County on that date, did you have possession of some methamphetamine?
Yes, sir.
Did you know that that's what that was?
Yes.
Did you have any legal right to have any amount of it at that time?
No, Your Honor.
Had you previously been convicted of possession of a controlled substance back in 2020?
Yes.
Mr. Roller, are the people satisfied with the factual basis?
Yes, Your Honor. Thank you. Yes, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on them?
I'm aware of none, Your Honor.
And are the people satisfied that the court has complied with statute and court will in the taking of this plea?
Yes, Judge.
Mr. Trick?
I am satisfied.
Mr. Fick, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this added count 2. The court will accept your guilty plea. The court will set this for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Church between now and then. Before you leave today, you're going to meet with Mr. Leo from the probation department to set up the time for pre-sentencing.
Yes, sir.
That's all for today. Thank you. Mr. Church, do you represent Mr. Bonamy?
I do.
Okay. I have that on 945, case number 216097 versus case of Bonamy. I want to proceed on that case.
Well, Judge, I don't really have a good answer for the court. I spoke to Mr. Bonamy yesterday. I talked to him about this hearing. In addition to that, we arranged to have Judge Cooper address a bench warrant that was issued out of the district court, frankly, because Mr. Bonamy was concerned he was going to get arrested and came here today. So we arranged for Judge Cooper to address that at 9 a.m. today. Mr. Bonamy was going to meet me here. We would zoom into Judge Cooper's court and address that bench warrant so that he could appear here today to address this matter. That's the last contact I had with him, was that conversation yesterday.
So he did not.
He was not here this morning. I tried to contact him, did not get an answer.
And Mr. DeLeo, I know you're not the supervising agent on Mr. Bonamy's case, but do you have any information?
I do, Your Honor. After he posted bond and was released, Agent Davis did have some contact with him. He had only instructed him to her 15th of August, he failed to do that. She then instructed him for the 2nd of August. He did fail. Some of that communication he was trying to do was in the
Do we have any outstanding warrants for Mr. Bonamy at this time?
I don't think we do, Your Honor, because I believe the last one we had, he was already down.
Okay. And Agent Davis has not filed any violation, show causes or bench warrants for his failure to report to her in August.
No, I believe what she did was just requested the court to get the other PVs that were already pending just back in front of the court. Okay. Which is what today's hearing is.
Okay, so if you can communicate with her, ask her to prepare a bench warrant for his arrest for his failure to report to her in August and his failure to appear today. I guess rather than treating that as a contempt or some kind of bond violation, or just treat it as an additional probation violation. Thank you. Our next hearing set for 10 o'clock. We'll take a short recess.
And I think we had, Mr. Evans was on.
He is. I need a minute to
Oh.
get that PSI together. I was going through the challenges and my paperwork's all over the place. So.
Understood.
Maybe let's take about 10 minutes and we'll be back.
All right, please.
Mr. Evans, are you able to hear me okay?
Yes, sir. Yes, sir.
Okay, we're on the record now in People versus Jason Evans, case number 236554. The record should reflect that Mr. Evans is present today by video from the Department of Corrections. If I could have counsel put your appearances on the record.
Thank you, for the record, my call that.
Thank you, Your Honor. Richard Trish, on behalf of Mr. Evans.
Thank you. Mr. Evans, just before we get started, I know we addressed this before, but I want to make sure that nothing has changed. You understand that you do have the right to have this hearing in person here in the courtroom in Otsego County, and that if you wanted to exercise that right, I would sign an order to have you transported here.
Yes, sir. Yes, sir.
Okay, and are you willing to waive that right and have that hearing by video as we're doing?
Yes, sir.
Okay, thank you. Mr. Evans, did you have an opportunity to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, I did.
Do you need any more time to do that before we go forward today, or are you ready to proceed?
I'm ready to proceed.
Thank you. Mr. Trush, I know that there's a challenge to the scoring of OB12 and OB15. Before we get to that, are there any additions, deletions, or corrections that need to be made to the body of the report?
There is one issue that I would raise for the court in regards to corrections. It's on CFJ 284A, and it is in description of the offense narrative.
Okay.
I'm looking at the second paragraph, second to last sentence indicates, and this is in reference to a discussion with the CI in regards to the case. Information was provided regarding drugs he was selling, guns in the home, and where Evans hides narcotics. I think that's a misleading statement. This is a recorded conversation. The recording is part of the discovery pack. The statements that the CI makes in regards to guns is that she has not seen any guns in the home. So, I mean, it's not technically an untrue statement what's contained in the PSI. I don't think it really accurately represents what the CI indicated in that recorded conversation.
With all due respect, Your Honor, people would disagree. The statements are not inconsistent at all. The CI said, although they knew where things were being hidden in the home, they didn't personally see any of the guns. I don't think you see any inconsistency at all, and I see no reason to change it.
All right. Well, first of all, the weapons don't form the basis for any of the sentencing offenses in this case. Given the information in the report, I don't find the weapons issue to be particularly relevant to the court's sentencing decision today. Given the statements of Mr. Evans' father in relation to those guns and how they were kept, I don't think that I haven't heard the recording, but from what the lawyers are telling me here today in the record, I don't think the statement in the report is inconsistent. I'm not going to order that it be altered, but certainly the court will take into account, to the extent that it is relevant to sentencing, the clarification that you've made here, Mr. Truth. Any other corrections, additions, or deletions?
No.
Okay. Then the first challenge to the scoring is as to OB12. It's currently scored at 10 points. Your argument is that it should be scored at 0 points. Just as a point of clarification, based on your brief, are you challenging that variable as to all 3 counts?
So, the specific challenge that I'm making is as to counts 2 and 3 specifically. I think there's an argument, frankly, that it could be challenged as to the maintaining of drug house, but in candor to the court, I don't think I'm successful on that. So,
okay. So, and just for clarification, when you say counts 2 and 3, you're referring to the information.
Correct. So the 2 possession counts.
Right. Okay. And maybe we should call them that for clarification, because in the PSI, it's charge 1, 2, and 3. Of course, it's different numbers in the information. So. Counts 2 and 3 of the information, which are 2 possession charges, your challenge is the scoring of 10 points as to those 2.
Correct.
Okay. Any record that you wanted to make of your argument in addition to what's in.
I just very briefly, I think the argument's pretty straightforward. I didn't get a response from the prosecutor, so I'll go over the basics of it just because I don't know if maybe he didn't have an opportunity to review it. It's not uncommon necessarily that I don't get a response, but still. I think that the record was very clear when we did the plea. We provided the court with 3 different reports to form the basis for the charges. Supplemental report 1 was provided to provide the basis for 1 possession of methamphetamine. Supplemental report 2, I believe, was provided for the other basis for the 2nd possession of methamphetamine. And then an affidavit of probable cause was provided for the basis for maintaining the drug house. The dates of those are crystal clear within them. It's about a month's time, I think, that lapses between supplemental 1 and supplemental 2. And then we have a several month gap before the next one occurs. So by definition, in order to be a contemporaneous felony act and score, it has to be within 24 hours. I don't think we have that here. And again, in my opinion, I think that's crystal clear.
Thank you, Mr. Rowland.
And again, Judge, I don't think there's an issue in regards to 2 and 3, the report dates or the incident dates that they are. But as the court's already reflected, that would not apply to.
Okay, so as to the 2 possession charges, the challenge to OB 12, the court has to find by a preponderance of the evidence that there are 3 or more contemporaneous felonious acts. Those are acts that occurred within 24 hours of the sentencing offense and acts that would not result in a separate conviction. The court is to look beyond the sentencing offense and consider only separate acts or behavior that did not establish the sentencing offense. Those are underlying criminal acts, not the number of crimes that could have been charged arising out of it. In this case, I think you do have an issue with regard to a 24-hour time frame. Obviously, there were a number of felonious acts that were taking place on or about the times that the sentencing offenses occurred. But I don't think the court has sufficient evidence to find that 3 or more of those took place within 24 hours of each of the 2 possession charges. So for those reasons, the court finds that the challenge should be sustained. And so the court will order that OB 12 as to the 2 possession charges be changed to 0, which then changes the OB score to 5 and reduces the OB level to 1. That's the charges. Is that correct?
That is correct.
That's correct, John.
And then OB 15, Mr. Your argument.
So again, Your Honor, I think this argument is relatively straightforward. We provided the court with 2 different case sites to it. This is an offense variable. It is specific to the offenses. In this case, the offenses that were pled to did not contain a delivery. Now, I do think that the offense variables can allow the court to kind of look beyond what we're calling the charge, right? So in a scenario where something is pled down from, for example, say a delivery to a possession, but the core of what it is still a delivery, I think the court can still look at the substance of the offense. In this case, the substance of both of the possession offenses, frankly, are trash pulls. It's substances that are found in the trash that Mr. Evans takes out. That forms the basis for both of those possessions. I don't think by a preponderance standard, the court could find that those specific offenses have any indications of delivery in them. So again, considering that we have to look offense specific here, and then again, looking at People versus Gray, the court identifies there, the Court of Appeals, that we're not supposed to be looking at dismissed conduct. And it gives an example that actually is, in that case, relatively similar to this, where someone is charged with 2 counts of possession. 1 count is based on what's contained in their house. The other is what's contained in their car. In that case, MDOC sought to score them on the basis of the quantity contained in the car. What the court found here is no, that quantity is not what is relevant because that was a dismissed charge. the quantity for that specific offense is what's relevant. So again, I think that actually encapsulates the argument pretty well here.
Again, with all due respect, John, I don't think Ray is applicable in this particular case. The basis for the possession, in this case, showing a intent to possess with intent to deliver the trash bowl, in addition to the residues, also, when they did the search in the defendant's home, scales, bags, and perhaps of most importance, as indicated in the PSI, the defendant denied using any controlled substances. And so he's either possessing them to give to somebody else or possessing them with the intent to sell to somebody else. And also, Gray was in a situation where the basis of the court accepting the plea was effectively a pled down from the higher offense. Gray doesn't, I don't think it's even applicable in this particular case. I think it's more correct, especially in light of the fact that we have a situation where the defendant also pled to maintaining a drug house where these drugs are being used and or sold for that purpose, again, indicating that it's trafficking.
All right, I did have a chance to look at, and again, we're dealing with just the 2 possession counts here, right?
Correct, and I think kind of responsive to the prosecutor there, the maintaining a drug house is a different scenario. I mean, while not making any sort of admission here on behalf of my client, I think the court could find, in regards to that count based on what happened on that date there, that there's indications to support the scoring there. I think the court could find that. In regards to the specific possessions, again, we're talking about small amounts inside of trash pulls. I don't think that there's indications to support it there.
Okay, so OB 15, it's currently scored at 5 points. The court has to find by a preponderance of the evidence that either there was a delivery, that there was possession with intent to deliver, or that there was possession having a value or under circumstances that would indicate trafficking. I agree, and I think case law supports finding that the court has to score on, or cannot score on the basis of other drug offenses that were committed during similar timeframes, but dismissed as part of a plea agreement. So I agree from a legal standpoint that the position is true. So the question is there a preponderance of the evidence to support a finding that the trash pulls convictions for possession here meet any of those criteria under OB 15? And I find that they do. It's not just the amounts that were found in the trash pulls, it's the character of how that residue was found, where it was found. Those things indicate that there was packaging of controlled substances going on, which would indicate circumstances of trafficking. Also, I agree with Mr. Rollo, the fact that Mr. Evans denied using controlled substances. The fact that he was found in possession of those, he's not using them. Only on one other reason, I think logically why he would have them, and that's to sell them to somebody else. And so again, I think here it's not the amounts or the value of the amounts found, it's the circumstances that indicate trafficking. So the court finds under the preponderance standard, there is sufficient evidence to support scoring as to all 3 counts under OB 15. So the court will deny that challenge. I think as a practical matter, in terms of the guidelines, it wouldn't have mattered because we're at an OB level of 1 with counts 2 and 3 at least. So it does change the scoring. And correct me if I'm wrong, counsel, but I believe as to counts, the 2 possession counts, that would change the scoring to 10 to 28. Is that correct?
That is correct.
That's my understanding, Judge.
But the guidelines would not change as to the maintaining a drug house count, which would remain 5 to 28. Is that correct?
Correct.
Okay. Okay. Any other challenges to the scoring, Mr. Church?
No, Your
Mr. Rolla, do people have any additions, deletions, or corrections?
No, Your Honor, thank you.
Or do people have any challenges to the scoring? Anything on behalf of the people for allocation?
Judge, Court's not familiar with Mr. Evans. Court's familiar with Mr. Evans' records. These are 6th, 7th, and 8th felonies. There was a recommendation of 2 to 5 years and 421 days credit. Even under the guidelines, it's changed. Last time I checked, 24 months is within 28 months. I think the recommendation should be followed.
Thank you, Mr. Church.
Your Honor, I think this is a case that's somewhat sad. The court's familiar with Mr. Evans' history, and Mr. Evans is someone, unfortunately, that I think got somewhat pushed to the fringes of society at a relatively young age, and I think has kind of lived there since then. He's been before the court on several occasions. I've had occasions to interact with Mr. Evans through the years quite a bit, both as a prosecutor and here on the defense side. When I visited Mr. Evans in Carson City and went through the PSI with him, we had a long discussion. And we had a discussion about, if he continues down the path that he's on and continues to do what he does, continues to react and behave in the way that he does, he's going to continue to find himself in MDOC. And that's not what he wants. That's not where he wants to be. And he's a person who I think has strong connections to his family. He wants to be there for his family, and he wants to change the ways that he's reacting to things. If the court looks at his history, a lot of it's misdemeanor history. A lot of that misdemeanor history is driving related. I think that the recommendations here are relatively appropriate in terms of what the guidelines range is, meaning, a shorter MDOC sentence would seem appropriate given the circumstances. I can indicate Mr. Evans has reported to me that he's already started programming in MDOC. He may be able to talk to you a little bit more about the different programs that he's in now and some of the programs he's on a wait list for. But ultimately, I think the recommendation is relatively reasonable in terms of a shorter MDOC stay.
Thank you. Mr. Evans, was there anything you wanted to say today?
I just want to reiterate what Mr. True said, that I plan to take full advantage of the programs that are made available to me here. I just started a VPP on Tuesday, which is violence prevention programming. I'm on the wait list for ASAP, which is advanced substance abuse programming. And after today, I plan on signing up for a vocational village. The only reason I haven't done so yet is because you can't while you have pending charges.
Okay. All right. Thank you. Mr. Evans, I did read through the pre-sentence report. So that gave me some familiarity in addition to the police reports that I read for the plea hearing in this case, with the facts of the charges that bring you before the court today. Obviously, I'm familiar with your background and history based on other cases. And, I think what Mr. True said is very accurate. You've had a long history of being unwilling or unable to follow the law and just the basic rules of society and our community for a long time. You've always been kind of on the fringes of that, and for whatever reason, have felt that you shouldn't have to follow those rules or those laws, or they don't apply to you. And in most of your cases, your arguments aren't that you didn't engage in the wrongful conduct. You've always been looking for some kind of technicality, some minor thing that the police did wrong, and somehow you can avoid accountability for your actions, but your arguments have never been that you didn't actually do what you were doing. And I think that's going to need to change because otherwise you are going to end up continuing to come back before the court, and where you're at with your record now, there really isn't any other consequence other than more prison time. So I hope that you do take advantage of what's available to you there. I hope that you do make some changes, because I do believe, and I've told you this before, that you do have positive things to offer the community if you can conform your behavior to what's expected of people in the community. So I hope that you do take advantage of those things. I think that the recommendation is appropriate, even with the change in the guidelines. I think it adequately accounts for your behavior in this case, as well as your past history. It's within the guidelines. I think it's a reasonable sentence. The court is going to sentence you as to each of the 3 counts. As to what's listed as charges 1 and 2, which are the 2 possession charges, the court is going to sentence you to 24 months to 15 years as to each of those charges. As to charge 3, which is the maintaining the drug house, the court is going to sentence you to a period of 24 months to 36 months. You do have credit for 421 days served as to each of those charges. The court is going to order that the sentence in this case be served concurrent to your sentence in Otsego County docket 216127 and Montmorency County docket 225171 and concurrent to each other. The court is going to order restitution in the amount of $275 that's payable to the Otsego County clerk to be dispersed to Straits Area Narcotics. Crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $204 state cost. You do have the ability to seek an appeal of each of these sentences. The court is going to provide you, if you haven't already received it, with some paperwork that explains to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with any appeal. Mr. True, should I have left anything out?
I don't believe so.
All right, thank you, Mr. Evans. You are remanded to the custody of the state at this time. The court is going to disconnect.
Jason, I'm going to send you that release of property form. You'll get that in the mail from me, all right?
Okay, thank you.
Mr. Kwiatkowski, were you ready with your client?
I am, Your Honor. Good morning.
We'll call People versus Jamie Allen Rochelo, case number 24708. Record should reflect defendant present here in the courtroom today, but we did counsel for the case.
Thank you, Your Honor.
Mr. Rochelo, you can come right up to the podium.
Kwiatkowski on behalf of Mr. Rushlow, Your Honor.
This matter has been adjourned, I think, at least 3 times. So are we ready to proceed today, Mr. Kwiatkowski?
We are, Your Honor. At this time, we have not reached a resolution. I would indicate to the court. I guess I didn't have this matter adjourned 3 times. I think we were here once and we had a docket call pushed out. There was, I guess, a cell phone that was seized, taken into evidence and then dumped in order to get the information that was not cherry picked in this cell phone. I had to get an expert who went down to Lansing, who had set up a time with MSP to review this matter, get that download. That happened about a week and a half ago. I'm still waiting on an expert's report with respects to that. So I can respond to 1, the search warrant, 2, Mr. Rola's other acts motion, and also maybe provide some defense for my client in respects to the information that was on that phone. So there are some things that I'm still seeking some, I guess, time to look into, but the court would like to set this on a trial docket. We have no problem with that. And in the interim, maybe we can put it in a docket call to have those things done. My client did inform him. He's got a right to that speedy trial, and if the court wants to do a waiver of that or have him acknowledge that on the record today, we can certainly do that as well.
Well, I mean, and I understand that there's been things that have needed to be done, but it's been found over in March. It's now September, and I think I need to get it on the docket for trial, and we need to get a plea cutoff set so that
Very good.
we have some movement one way or the other. because we've just been consistently pushing it down the road. So in terms of trial, Mr. Rolla, how many days of trial do you think people would?
Judge, we have 1, 2, 3, 4, 5, 6, 7 witnesses. I think it's probably to be a 2-day trial. I'd also note for the record that we had a certificate status conference on April 15th, May 8th, June 17th. And as the court indicated, there was an original adjournment requested by defense back on April 15th. We're still waiting for that information.
Mr. Kwiatkowski, do you think 2 days is enough?
I'd say 2 days would be sufficient, Your Honor.
And Your Honor, for the benefit of the record, there was a plea offer in this case to drop the habitual enhancement. That's the offer in this particular case.
All right, so the court is going to set this for trial 90 to 120 days out. Mr. Kwiatkowski, if you are objecting to the admission of the evidence that Mr. Rolla is proposing to admit, then you would need to file an objection and contact my office for a hearing date. Have a hearing.
And I anticipate doing that, Your Honor. Part of that is there's a company case here in Sheboygan County that was charged in respect to that data on the phone. So I think it's twofold motion there. One, to dismiss in that file with respects to when an expert comes in with his report and information, but I will get that to the court as soon as possible.
And then the court will set this for a final status conference on its motion day immediately prior to the trial date. That will be completely cut off and motion cut off. Mr. Rolla, any other dates that I can address for your side today?
What would the date be for that final status, or would that be coming in?
Yeah, what'll happen is my office will send out the notice of the trial date, and along with that will come a notice of the final status conference. It'll be on the motion day immediately preceding that trial date. So usually it's like 2 or 3 weeks before the trial date.
Okay, very good, Your Honor.
All right, Mr. Rolla, anything else I can address for your side? Mr. Kwiatkowski.
Nothing for the defense, Your Honor.
Okay, thank you. That's all.
Thank you.
Okay, great, thank you.
Sir, can you tell me your name there at Department of Corrections?
Joshua Bell.
We'll go on the record in People versus Joshua Bell, case number 246738. The record should reflect that Mr. Bell is present today by video from Department of Corrections. And set for status conference, executive counsel, put your appearances on.
Thank you, Your Honor. Richard Church, yeah, Mr. Bell.
And Mr. Church, can you tell me the status of this case for the defense standing?
Your Honor, I'm not really sure how to proceed in this matter at this point. The last conference we had, I had indicated Mr. Bell had moved from the county jail. I think it was Sheboygan's County Jail, maybe, or Charlevoix, into MDOC. We needed an adjournment because we hadn't really had an ability to communicate since he'd been at MDOC. Since that time, MDOC has not allowed any contact with him. I've tried to arrange things via telephone. I've tried to arrange things via video communication. I even tried to arrange things via in-person visits. And at every turn, I've been denied. Frankly, I prepared a motion for the court to hold MDOC in contempt. But honestly, I don't want to go down that road. I don't think that benefits my client in any meaningful way. But I mean, I really don't know what to do at this point.
Have they given you a reason why they're not allowing the contact?
So as far as video and telephone, they basically told me that they just don't arrange those. As far as the in-person visits, they did offer to allow a visitation at 8 p.m. on a Friday evening if I drove, the 3 hours down there, which was just not feasible.
And what facility is Mr. Bell at?
He's at Egler at present.
Okay.
I believe. Is that correct,
Yeah.
Mr. Bell?
Yes.
I tried to arrange to see if I could meet with him when I was down meeting with Mr. Evans at Carson City, because they're relatively close. I mean, they're only about an hour apart, which is certainly better than, 3 hours I have to drive. Otherwise, I really just don't know what to do in this matter. I did receive last week a JPEG email from Mr. Bell. I responded back to it. I don't know if he got that response though, given, again, the timeframes of it. We do have an offer in this matter, but again, I haven't been able to have a lot of discussion with him about that offer.
Okay.
Sorry, I did, while Your Honor was, I believe, out of the office, Judge Hunter signed a writ to have him transported here physically for this hearing, so I might be able to talk to him in that way. MDOC denied that writ as well.
And that's the latter, that's what I was going to comment on, at the request of the court. As our office had been advised on the 27th of August, the issues with, which defense counsel just indicated on the record, our office did prepare a writ of habeas corpus that was served. I obviously, Mr. Bell is not your first school, so I guess that speaks for itself.
What kind of sentence, do you know what kind of sentence Mr. Bell is currently sitting on?
I believe that he had, when I last looked, somewhere, I think it was about a 2-year sentence and maybe 18 months or so left. Does that sound about right?
I have about 20 months left for the minimum.
Okay.
And
Sitting on dead time on this file?
he is, and that becomes my concern, is the more times that we have to adjourn this out, I mean, he's not getting credit for the time, and 2 sentences that might otherwise be served concurrently may not wind up that way.
All right.
Prior to, while we're here and while Mr. Bell's on the record, as Mr. Trish indicated, there was a plea offer. There was a plea to count 1, controlled substance possession of analogs with the drug double. The drug in question would be buprenorphine and Suboxone, and that would be inclusive of then with proof that he's now paying valid insurance rate has for dismissal of count 2.
All right. I guess this is how I'm gonna order that things proceed from today. Mr. Roll, I'm gonna ask that you prepare another in-person writ for Mr. Bell for next month. I'm gonna sign that writ and I'm gonna include an order from the court directly to DOC, which is basically gonna be, if they don't produce him, then they're gonna have to appear here on a contempt show cause. The court, Mr. Trush, recognizing that the delay here is not been the fault of Mr. Bell or the prosecution or the defense counsel, the court would be willing to consider, if eventually this results in a conviction by a jury verdict or a plea, additional jail credit for the delay in MDOC not complying with the court's orders to produce Mr. Bell. I don't think there's any prejudice in that, and I think that in the interest of justice, the court should grant, again, upon conviction one way or the other, Mr. Bell jail credit for time delays that have been caused by the Department of Corrections. And then we'll set this for another hearing. Would you like the opportunity to have a breakout room with them now, since we do have them?
If the court is inclined to do that, I would be happy to. Again, we had some discussion about the plea offer. So if the court's inclined to do that, yes, I would.
So I'll give you about 10 minutes in a breakout room. Mr. Bell, the court's going to connect you with Mr. Trush here so that you can have a confidential discussion with him, private discussion with him in a breakout room, okay?
Okay.
Paying attention. He's actually doing something in that.
Okay, Mr. Trush, if you can keep the meeting to about 10 minutes. I see we do have Mr. Massengill at 10:45 connected from Roscommon Jail, but I'm going to place you into a breakout room right now.
Okay, excellent, thank you.
Okay, we're back on the record in Mr. Bell's case. Mr. Trush, did you have a chance to speak with him?
I did, Your Honor. And we would like to adjourn it a month and have him transported in person.
Okay. All right. So Mr. Bell will take the appropriate actions to be able to move forward with your case. Mr. Rolla, anything further on this matter?
No, Your Honor, thank you.
Mr. Bell, do you have any questions at all?
No, Your Honor.
Okay, thank you. That concludes this hearing and the court's going to disconnect this time. All right, sir, are you Christopher Bassengill?
Yes, Your Honor.
All right, we'll go on the record in People versus Christopher Massengill, case number 246739. The record should reflect that Mr. Massengill is present today by video from Roscommon County Jail based on prior waiver of personal appearance. Mr. Rolla and Mr. Trush are present here in the courtroom. This is the date and time set for sentencing. Mr. Trush, did you have a chance to go through the report with Mr. Massengill?
I have.
Mr. Massengill, did you have an adequate opportunity to go through the pre-sentence report with Mr. Trush and talk to him about that?
I have, Your Honor.
Okay, Mr. Trush, are there any additions, deletions, or corrections that need to be made to that report?
No, Your Honor.
Are there any challenges to the scoring guidelines?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor, no challenges as to guidelines.
Mr. Rolla, anything on behalf of the people for allocution?
Judge, the situation we're talking about a night felony, 7 controlled substance offense. The guidelines in this case are 10 to 28 up to 15 years, which means the court has a number of options it can do. Generally, though, as opposed to under 33 months as the main limit is an impression in county time. The recommendation in this case is jail with 16 days credit. If the court feels that county time is appropriate, we'd ask that the court impose basically the year in jail with 60 days.
Thank you, Mr. Trush.
So, Your Honor, this is a somewhat unique case. And it's unique in the sense that Mr. Massengill has similar allegations that arise around the same time, one in Roscommon and one here. Roscommon's matter resolved itself quicker than our matter here did. And part of that, frankly, was he was in their jail there. I think when the court crafts a sentence, looking at what's happening there is probably an important thing to look at. And I say that because Mr. Massengill has been sentenced there. He was given a 9-month sentence on the allegations in Roscommon. Part of that sentence made him eligible to get into a treatment program. He is, I think from my discussions with him, about 6 or so weeks away from being able to enter that treatment program. He's been doing everything he can in the county jail there in terms of addressing his substance abuse issues. He's a trustee there. He reports to me about 12 hours a day in their kitchen. And again, he's on the doorstep of being able to get into an inpatient treatment facility. He's going to tell you that's what he needs. He needs to address the substance abuse issues. Now, as I see it, the court has a couple different options. The recommendation here from MDOC is a county jail sentence. And frankly, that makes sense to me, given the context of everything that's going on. What I would suggest to the court, though, is taking into account what's going on in Roscommon, crafting a type of blended sentence may make more sense. And what I mean is, I think everybody probably accepts that there's a punishment element to what happens. He's been in jail there for, I think, about 6 months at this point, and again, eligible for treatment in a short period of time. What we could do is we could issue another jail sentence here and effectively hold him in jail long, right? Up to a year here in jail in addition to what he's already served. My contention to the court would be, I don't know that that's really what results in the best outcome. What I would suggest is a blended sentence where the court imposes a little bit up front, but allows him to get into that treatment. holds the bulk of the jail in abeyance, and if he doesn't do the treatment and doesn't continue to address the issues, then impose that jail. I think that both punishes him with the time that he's already served and a little additional time. But what it really does is hold his feet to the fire in terms of continuing to address the issue, right? Not just finishing this and being on his way. And I think we all know the longer he abstains from substances, the better the overall prognosis for him long-term success. So the longer we can hold his feet to the fire and keep him clean. And I think we all accept that probation is going to be an incentive to keep it clean. I think that's what makes the most sense as a sentence here. Again, he's going to speak to you a little bit as well. He's going to tell you he needs the intervention. And I would ask the court to craft a sentence that allows him to take advantage of that.
Your Honor, I don't know if Mr. Truce is aware of it or not, but I just complained with the information rule. I don't know how the defendant could actually be allowed to enter that inpatient unit, because he's got a hold on him out of Wayne County for other felony charges.
I mean, I think I don't know anything about that. He might be able to address it, and it's entirely possible if that's been resolved. I don't know.
All right. Anything more for allocution, Mr. Church?
No, Your Honor.
All right. Mr. Massengill, is there anything that you wanted to say today?
Yes, Your Honor, I've always just been in and out of jail. I'm finally I'm old where I don't want to mess up no more. I'm trying to get help. I asked for help. They're giving me help here. I'm lined up to go to rehab shortly. I should be 7 months in by the time I'm eligible to go to the rehab. Everything's gonna be taken care of. That Detroit case downstate was a probation violation, which was a misdemeanor. I'm gonna get that taken care of right here with what I'm doing. But you know, I've never had help. I've never had the chance to go to rehab or anything. You know, I'll do a little time and get out. But if you could, you know, I don't know, run it with this and then hold it the rest in abeyance, and I'll show you that I can do it.
All right, Mr. Massengill, I did have a chance to review the pre-sentence report, so I'm familiar with the charges in this case and the factual basis for the charges. I'm also aware of your past record and history based on the information contained within the report. And taking all that into account along with what the lawyers and yourself have had to say here today, although the guidelines would potentially call for a prison sentence, looking at the facts of this case, I don't think it's justified. I think a jail term is more appropriate to address the wrongful conduct here. I'm also not opposed to providing some avenue for rehabilitation. I don't know, you know, what's going to happen with your treatment program there, and whether you're going to be eligible for that, and whether and to what extent your other issues are going to interfere with that. But what I will say is, you know, I'm going to sentence you to a straight jail term here in Otsego County. If I get some kind of written confirmation that you're eligible, there's a bed ready for you at a treatment facility, then I would be willing to hold the time remaining here in Otsego County in abeyance for you to be released to treatment. In other words, if the only thing preventing you from going into a residential treatment program is your jail term here, then I would hold that in abeyance and allow you to go into treatment. If you were to leave treatment or unsuccessfully complete it, or you know, not complete it successfully, then you would have to return to jail here and finish your sentence. So
Okay.
I will provide for that as a possibility, but until I get, you know, written confirmation that there's a bed ready for you to be available, then you know, the sentence here would stand. So the court is going to sentence you to 12 months in the Otsego County Jail. You do have credit for 16 days served.
16?
Yes, 1-6. A crime victims assessment.
Sorry.
What's that?
Sorry, I was just wondering, I didn't know that I could have pulled my bond when I got here and I would have been, the time would have been running together that I've been sitting here. I bonded out of there to start taking care of this place. They come and got me, you know, so I was taking care of my stuff. Could you run this all together with the time I've been locked up?
Right now, according to my records, you're eligible for 16 days of credit, so. That's all I'm allowing today. If you want to try out, you know, if you want to try to file some type of motion and give me some kind of legal justification for why you're entitled to more, then I would consider that. But at this point, you're entitled to 16 days.
Thank you, Your Honor.
A crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence. If you haven't already received it, you will be provided with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed attorney. And again, Mr. Massengill, if you're able to get a bed and get treatment set up, then have that facility provide some type of notice to me in writing. And again, I don't have an issue with giving you an early release and holding the time in advance for you to go to inpatient treatment, okay?
Okay, Your Honor, thank you, I appreciate it.
Mr. Roll, anything further on this file? Mr. Trush?
So, Your Honor, in Crawford, we have an option to submit like a form rehab order. Does the court want us to submit that with written, I guess, verification of the bed?
That would be great, yes. Yeah. All right, thank you. That's all for today. Mr. Massengill, we're going to disconnect at this time.
Thank you.
We did have at 10:30, Mr. Trush, People versus Jesse Williams, case number 24667. You got any contact from Mr. Williams? Oh.
I did, Your Honor. I spoke to Mr. Williams yesterday. I'm surprised he wasn't here when I noticed that we were getting close to this time and he wasn't. I sent him a message, but I haven't heard anything back.
Okay. The record should reflect that hearing was set for 10:30. It's now 11 o'clock. The court would note for the record that this is a sentencing hearing. Mr. Rolla, the court would request that your office prepare and warrant for Mr. Williams' arrest. Once he's arrested and brought before the court, we'll proceed with the sentencing.
Very good, Your Honor.
And Mr. Clingan, I just need 1 second and take up Mr. Baskett's. on record in People versus Taft, case number 236564. The record should reflect Mr. Taft is present here in the courtroom today. If I get counsel, put your appearances on.
Thank you, for the record, we're going to.
Thank you, Your Honor. Good morning, Brian Clean, behalf of Taft.
This is the date and time set for a sentencing hearing in this matter. Mr. Taft, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Clayton about that?
Yes, Your Honor.
Mr. Clayton, are there any additions, deletions, or corrections to that report?
Yes, Your Honor. On page 1, under additional information, located right below evaluation plan. All of the statement contained in the additional information may be accurate with regards to the Michigan State Police may or may not be investigating. I don't think it's relevant. I don't know how it's relevant to the pre-sentence investigation report going forward. There might be an investigation, there might not be, but there's no charges being filed. He's not. I just don't see how that's relevant to this hearing.
Mr. Rowland.
And again, I don't know that it goes to the specific sentencing.
Yeah, I'm going to order that be stricken from the report. I don't know whether and to what extent there are additional investigations. Certainly it would have anything to do with the court's sentencing consideration here. So the court will order that be stricken.
With that being stricken, Your Honor, the rest of the report does appear to be factually accurate and relevant.
Are there any challenges to the scoring of the guidelines?
No.
Mr. Rolla, did the people have any additions, deletions, or corrections?
Judge, the only situation that I would say has to be corrected in the Protection Act, in the body of the report, would be under the recommendation, the firearm in this case has to be confiscated and down pursuant to statute 75239.
Okay, so that would be added to the count 1.
Correct, Your Honor.
Plan, I believe that's an accurate statement of the law. The only other question I had with regard to that recommendation, and Mr. DeLeo, maybe you can address this, it indicates 2 days of credit for count 2, which is the felony firearm. Should it be 2 days of credit for count 1 instead?
Well, I think the recommendation, because of that mandatory consecutive, I think that's what Brennan was applying to count 2.
Okay, so that
has to be served first.
That's correct. Then, okay. All right. Mr. Rolla, any other corrections, additions?
No, Your Honor, thank you.
All right. Mr. Rolla, any challenges to the scoring?
No, Your Honor, thank you.
Anything on behalf of the people for allocation?
Judge, in this particular case, the court statute trial says this is third and fourth felony involved firearms. He knows you can't have them regardless of the excuses that were attempted to be made and on this trial. The jury obviously didn't buy it. The recommendation in this particular case, I think, is appropriately escalated.
Thank you. Once again, the court did sit through the trial in this case. I think this case is distinguishable from other cases or similar cases. The court obviously has to look at the offense and the offender. And looking first at the offender, looking at Mr. Taft's prior record, I acknowledge that he does have felony convictions. Some of them are quite old. The most serious ones are over 20 years old. He scores out his 39 points on his prior record variables, which is it's over the midpoint, but it's not high, with 75 points being the highest assessed. The offense variables are 0, which is the lowest possible being assessed. He falls into a straddle cell. I think the positives that Mr. Taft has is he takes care of his family, he supports for his family. He is self-employed, he takes care of a business, he's got clients, he's got a lot of positives going on. His criminal history, although in his early years was rocky, in his mid years and most recently, it's been mostly driving license suspended, driving without insurance. Although crimes are not considered crimes, that would be public safety or public interest type crimes. In this case, although I have no choice but to accept the jury verdict, I remain resolute, as does Mr. Papp that he didn't have possession of the gun. I don't think even the prosecution's theory of the case was they had actual possession of the gun. I think it comes down to reasonable access to the gun, and the gun was located in the house where he resided. We hoped that the jury would see it differently than they did, but they didn't. The fact of the matter is that Mr. Papp does provide, he does seem as though he's reformed his life rather dramatically from his early misgivings. He sits here in front of the court on a straddle cell. He's a 5 to 46 or 5 to 23 without the supplementation of 5 to 46. The court has a great deal of discretion in looking at the offense and the offender and recognizing that there's a 2-year mandatory proceeding and consecutive. In fashion, the sentence, the court's mandated to that, but then as part of the remaining sentence, what is appropriate? I don't think long-term incarceration serves any purpose. I think it just warehouses Mr. Papp. I don't think it makes the public any safer. Matter of fact, arguably the public's better. Mr. Papp's out working and providing for his family. So the court has a wide range of discretion with regards to the second part of the sentence, even if you're mandated at the first part. I see no reason why Mr. Papp would have to serve middle or high end of the guidelines. He could very easily serve low end of the guidelines and serve the same purposes of sentencing. I would feel differently about the case if Mr. Papp had used the gun, but possessed the gun. Actually, there's no evidence of either. So I'd ask the court to consider a sentence at the low end of the guidelines. And I'm recognizing that might result in a bit of a legal conundrum that he serves the 2 years, and comes back and serves a county jail sentence. That might not be appealing to the court, but that's certainly within the court's purview with the sentencing guidelines as they're currently positive. I don't see any justification for a sentence of 30 months or even 24 months after Mr. Papp has already served 2 years. So I'd ask the court to consider a low end of the guideline sentence, acknowledging that Mr. Papp will be out of public domain for the first 2 years of the sentence.
Thank you. Mr. Papp, anything that you wanted to say today?
Yes, Your Honor. I am sorry here for wasting your time. I did not possess that gun. It was in my house. I did not have possession of it ever, but because of the person that was there and with the stuff that he's done while my wife had it, it was never around me. I've never touched it or anything. I had it so my wife can protect herself, my 4-year-old son, Sunday, and my stepdaughter. That's the only reason it was there, because Tom Serena kept coming there. We tried to go to the police. They just kept telling us no. So we looked up, we called everybody, called the Attorney General, we called state police. What do we got to do to make this legal? So we did. We thought, or at least I stand here saying I thought I did, because I really thought I did. But in my time of being younger and being incarcerated, I learned this is not for me. I started my own family. But my son, they couldn't be here. They told me couldn't be here today. I started my own business. I had handyman service, and I help people from Gaylord to Boyne all the way to where I live over there at Courtroom. And now I gotta sit here and ask for leniency for something I know I didn't do. And in my heart, and then God looking down, knows I had nothing to do with this, and I shouldn't be standing here asking and begging you for forgiveness or for leniency. I mean, so my family doesn't get ripped apart more than it already has.
All right. So obviously I did sit through the trial. I heard all the evidence, all the testimony. So I'm aware of the factual basis for the conviction here today. I did read through the report, so I'm familiar with all the background information regarding you and your prior history, as well as your personal history. And taking all that into account, along with what the attorneys and yourself had to say, number one, with regard to the felony firearm charge, that's something that's really outside of the court's hands. That's a statutory requirement based on the conviction. So there's not much to be said for that portion of the charge. In terms of the possession of a weapon by a felon, the law is pretty clear. It doesn't have to be in your hand. You don't have to use it. You can't be in actual or constructive possession of a weapon. And as somebody with a felony conviction, it's your responsibility to know and understand the law regarding weapons, and when you can be around them and when you can't. It's pretty clear that having that weapon in that house with you present in the location it was in, and clearly unsecured, you did have access to that. You could have grabbed that weapon at any time you wanted to. The way that it was locked, based on the evidence that was presented at trial, wasn't really locked at all. Could have been used by anyone. So, you know, it was a completely inadequate way of trying to keep a weapon in a home with someone who was legally not allowed to be around weapons. And again, the law presumes that it's your responsibility to know and understand that. And when you don't take enough care, then you wind up in the situation that you're in. The guidelines in this case, as Mr. Clayton indicated, are 7 months up to 46 months. I think a sentence within the middle of the guidelines is appropriate. I think it accounts for your conduct in this case. I think it addresses your prior history. I think it's a reasonable sentence given the jury's verdict, and I think it is proportionate to your conduct in this case as well as your past history. So for all those reasons, the court will sentence you as to the possession of a firearm by a felon to 24 months to 5 years with Michigan Department of Corrections. There is 0 days credit as to that charge. The court will also order, as Mr. Rowe indicated, as the court's required to by statute, forfeiture of the weapon involved and a $68 state cost.
Judge, there is a correction to BSI cost, this to count 2, shouldn't be 345, 32,500. It should be $325.
Right. As to count 2, 2 years in the Michigan Department of Corrections with credit for 2 days served. That to be served consecutive to and preceding count 1. Crime victim's assessment of $130, court costs of $325, and the state cost of $68. Have the ability to seek an appeal of the sentence, and Mr. Clayton, if you can, have to challenge this appellate rate.
Keep your head up. Take care of myself. You're
Glad to go forward. One more hearing, 11:15 people versus Spihar, I believe he's Flash. Jail. Yeah. You just need input. Right? Mr. Gilo, we're getting Mr. Spihar on video here.
Very well.
Spihar, yeah.
All right, sir, are you Kevin Spihar?
Yes, sir.
Okay, we're on the record now in People versus Kevin Spihar, case number 226450. The record should reflect Mr. Spihar is present today by video from the Otsego County Jail. We have present by video also Mr. Gilo, his attorney. Here in the courtroom is Mr. Rolla on behalf of the people. The court set this for a status conference today. Mr. Spihar was, I believe, recently lodged here in Otsego County based on a bench warrant that was issued back in May of 2023 for his failure to appear. Mr. Gilo, have you had any chance to talk to Mr. Spihar? This had been originally set for trial. You know how we want to proceed with this case?
Yeah, Judge, I had a meeting with him personally. We discussed a lot of things, most importantly, the plea offer that's been offered by the prosecution. We wish to accept the same.
Okay, can you tell me the terms of the plea offer?
My client would plead guilty to count 2, assault, R&O, and count 3, domestic violence. For dismissal of the home invasion, which is count 1, and the habitual offender enhancement.
That's what the offer was, Your Honor.
Okay. Mr. Spihar, were you able to hear that?
Yes, sir.
And have you had an adequate opportunity to talk to Mr. Gilo about that plea agreement?
Yes.
Is that how you want to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Spihar, are you currently on any kind of probation or parole?
Not yet, but I will be.
Okay. All right. And you understand that the maximum possible penalty you could face for the charge of resisting or obstructing a police officer is up to 2 years and a $2,000 fine. You understand that?
Yes.
And the maximum possible penalty that you could face for domestic violence, which is a misdemeanor, is up to 93 days and or a $500 fine. You understand that?
Yes.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, I do.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here on the record today?
No.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you are guilty of each of these charges?
Yes.
The information I have indicates that this happened back on September 15th of 2022, so just about 2 years ago. Is that correct? Could you repeat that? I'm sorry.
Yes, sir.
Okay. On that date, were you at a residence on Pinecrest here in Otsego County?
Yes,
All right, and did you have an altercation with the Nicole Ashton on that date?
yes,
Did you have a dating relationship with her at that time?
yes,
Okay. And did you have some kind of physical contact with her?
yes,
All right. And was that unwanted contact? In other words, you were touching her in a way that she didn't want to be touched?
yes,
And were the police called to that location during that incident?
yes,
Okay. Was that a police officer from Otsego County Sheriff's Department?
yes,
Did you know that he was there acting as a law enforcement officer at the time?
yes,
And did he give you some commands or tell you to do something that you did not comply with?
yes.
What was he asking you to do that you didn't comply with?
Come out with your hands up.
Okay. And he was there responding to whatever was going on with you and Miss Ashton?
Yes.
All right, Mr. Roller, are the people satisfied with the factual basis?
So as the court finds that this we're not seeking, yes, Your Honor.
You have testimony that it was on Pinecrest and.
Very good. And so the court have to take judicial notice, but just so the record's clear, that's all. Thank you.
Okay, Mr. Gilo, are you satisfied with the factual basis?
I am, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor, thank you.
Mr. Gilo, are you?
No, Your Honor, thank you.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea? Mr. Gilo?
Yes, Your Honor.
Thank you. Mr. Spihar, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. As to each charge, this matter will be set for a sentencing hearing. Between now and then, you'll be contacted by the probation department for a pre-sentence report. Mr. Roll, anything further we need to address today? Mr. Gilo, anything further we need to address today?
No, Your Honor, thank you.
Okay, thank you. That's all for this hearing. The court's going to disconnect. This also concludes the court's morning docket. Court will be in recess until